Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and today I will talk about the case of Garg Builders versus Bharat Heavy Electricals Limited, wherein the Honorable Supreme Court discussed the concept of pendente lite interest in the context of arbitral proceedings. Before adverting any further, let us understand the bare meaning of pendente lite and Section 31, subsection 7a of the Arbitration and Conciliation Act 1996. Black's Law Dictionary defines pendente lite as during the proceeding of litigation or in a manner contingent on the outcome of litigation. Thus, pendente lite interest means the interest that is granted to the parties on account of pendency of litigation. If a litigation persists for a particular period of time, then pendente lite interest may be granted for that particular period of time for which the litigation took place. The rationale behind the concept of pendente lite interest is to compensate a party in proportion to the amount of time that it has spent on litigation while claiming its rightful dues from the opposite party. In this regard, Section 31, subsection 7a of the Arbitration Act provides that unless otherwise agreed by the parties, where and insofar as an arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. Therefore, Section 31 subsection 7a provides for party autonomy and states that though the arbitral tribunal may grant pendente lite interest on the sum of the award, but the same is subject to the agreement that has transpired between the parties. Hence, if an agreement prohibits such grant of interest, then under Section 31 subsection 7a, the arbitral tribunal is also prohibited from granting pendente lite interest. The facts of the case are not necessary for the purposes of this show, and hence the same are not being discussed here. In order to understand the concept of pendente lite interest in a better manner, let us go through the pertinent observations by the court. Firstly, the court noted that if the contract prohibits pre-reference and pendente lite interest, the arbitrator cannot award interest for the said period. Secondly, the court observed that a provision has been made under Section 31, subsection 7a of the 1996 Act in relation to the power of the arbitrator to award interest. As per this section, if the contract bars payment of interest, the arbitrator cannot award interest from the date of cause of action till the date of award. Thirdly, the court cited various case laws to explain that where the parties had agreed that the interest shall not be payable, the arbitral tribunal cannot award interest between the date on which the cause of action arose to the date of the award. Fourthly, the court clarified that if the contract contains a specific clause which expressly bars payment of interest, then it is not open for the arbitrator to grant pendente lite interest. Fifthly, the court also cited Section 3, subsection 3a2 of the Payment of Interest Act 1978 that provides that the Interest Act will not apply to situations where the payment of interest is barred by virtue of an express agreement. And lastly, the court concluded by stating that when there is an express statutory permission for the parties to contract out of receiving interest and they have done so without any vitiation of free consent, it is not open for the arbitrator to grant pendente lite interest. Therefore, I hope that the meaning of pendente lite interest is clear by now. So what are my concluding remarks? I concur with the reasoning of the court that party autonomy is paramount. Once parties, out of their free volition, have agreed that there shall be no payment of interest, then later on they cannot contend that interest should be granted to them. Further, Arbitration Act is a special legislation governing arbitration matters. When Section 31 subsection 7a unequivocally gives precedence to party autonomy over grant of pendente lite interest, then even a general law that provides for payment of pendente lite interest would be of no help, since it is a settled proposition that special law supersedes the general law. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.